Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back out now to the big en banc argument coming out to the Third Circuit in the matter of Cheeseman v. Platkin, set for October 15th. Now, as we know, the United States Department of Justice has chosen to weigh in with an amicus brief, and apparently a few days ago, the state of New Jersey woke up and was in a really, really bad mood. Somebody apparently had peed in their Cheerios. Who was that? It was the Department of Justice because, well, the state of New Jersey is taking big exception to what the United States Department of Justice has argued, has filed a nasty little response brief to an amicus brief. Think about that for a second. We're going to go through it. We're going to show you where all the sour grapes lie. So today, let's spend a few minutes and let's talk about New Jersey throws a tantrum at DOJ. Okay, America, as we know, because we've been talking about this, and if you actually go back in the time machine, you will see that we've been talking about this for a few months now, that all of these stars could line up in the Third Circuit, and New Jersey could actually be walking into a bit of a buzzsaw that they may have not seen coming. Wouldn't that be cool? The case we're talking about today is Cheeseman v. Platkin. There's several cases consolidated, including the matter of Association of New Jersey Rifle and Pistol Clubs, Inc. versus Attorney General of New Jersey. This response brief was technically filed under that caption, but it's all the same thing. Now, as we know, the plaintiffs will file an opening brief. Defendants will then reply with a brief themselves, and we may have amicus parties that will weigh in on one side or the other. I have never seen an occasion where the defendant has actually chosen to file a response brief to an amicus brief. They will file response briefs to the petitioner's brief all the time, but to an amicus brief, no, not very often. And in this case, the state of New Jersey has seen the need to respond to the United States Department of Justice's amicus brief on this case. And here's essentially the arguments they're making. Number one, there is no circuit split, so obviously this law is constitutional. And number two, the common use test is a bunch of BS. Now, we're going to spend most of our time with this outright frontal attack on the common use doctrine in a moment. But, you know, we talk about this all the time, the jurisdictional bubble, and when we take a look at the map here and why there isn't circuit splits. But I say every time I read a brief that deals with a magazine ban or a platform ban or anything like that, we get this shoved down our throat. This is an example. This is how it happens. The federal government asked this court to split with 6 of its sister circuits. And it asked this court to do so even though the United States itself maintained federal restrictions on both assault weapons and large capacity magazines for a decade. This court should decline that invitation. And then, of course, I do want you to see the cases that were cited saying that, well, obviously this is good law. Then they began what is a long, full frontal attack on the common use doctrine. It begins this way. The federal government, echoing the challengers, errs in contending that the exclusive justification for a firearm regulation turns on the firearms circulation. No court of appeals has ever agreed with the challengers that the volume of a restricted item in circulation is the dispositive constitutional test. Be that as it may, the United States Supreme Court has agreed with that, but why let that get in the way? They go on to state, and for good reasons, this test is ahistorical, leads to unavoidable protection for machine guns, is inherently illogical, and produces an arms race between manufacturers and officials, is inconsistent with the treatment of other constitutional rights, and finds no support from precedent. And I want you to know that this whole, if you do this, they're going to legalize machine guns, is literally a theme that the state of New Jersey weaves throughout this entire brief, okay? The federal government's efforts to rehabilitate this popularity test, including to argue that machine guns can be regulated on its view, do not pass scrutiny. Okay, so now we're going to take a look at all of the very childish and ridiculous attacks that the state of New Jersey makes on the common use doctrine. And obviously they don't want the common use doctrine, because if the common use doctrine is the law of the land, which it is, then none of these bans, not only New Jersey's, but none of these bans can withstand constitutional scrutiny, and they recognize that. So they go about it this way. The federal government badly claims that states cannot ban arms that are in common use without running afoul of the Constitution. The federal government, like the challengers, reached its results based on conclusions that 1. Common use is the sole analysis for firearms regulation, and 2. Common use refers to the number of items in civilian circulation. That is exactly how the common use test, that is exactly how it's applied. But New Jersey says both steps in the logical chain are faulty. Now, New Jersey then goes off the beaten path and starts talking about historical analysis. And again, we don't need to be doing this on platform bans. We don't need to engage in a historical analysis. It's already been done. If they're in common use for lawful purposes, they cannot be banned. The only history we have of banning things are items which are dangerous and unusual. But of course, the state of New Jersey cannot accept that. So they go about it this way. First, despite Bruin and Rahimi's emphasis on history, a circulation-only test is fundamentally ahistorical. The federal government's myopic focus on an item's popularity ignores that American governments have long prohibited weapons when those arms were widely available in the civilian population and had been used for lethal criminal ends. Indeed, such penetration was one reason why legislatures had acted to regulate them. But of course, if we actually take a look at any type of history that even sort of maybe comes close to what we're talking about here, we will find things about Bowie knives and other dangerous weapons, but it always deals with the carrying of those items. It never deals with the outright possession of them. Now, we mentioned this whole machine gun problem. And here's how the state of New Jersey thinks that the Third Circuit is this close to legalizing machine guns if they rule in favor of the petitioners. What they point out is that in Catano v. Massachusetts, it was determined that Massachusetts could not ban stun guns because there were approximately 200,000 of them in circulation. They also believe that according to ATF statistics, there's 176,000 registered machine guns in circulation, which means that they are put dangerously close to this 200,000 threshold, which has never truly been articulated as a threshold for the common use test. And so therefore, they would like to mischaracterize the common use test as follows. It hinges the right on a trivial counting exercise that would lead to absurd consequences where unusually dangerous arms, like the M16, can gain constitutional protection merely because they become popular before the government can sufficiently regulate them. Yes, you are absolutely correct about that. Let the record reflect that I actually agree with that paragraph on page 5 of the respondent's brief that, yeah, you're right. It is a mere counting exercise. And if they become too popular before the government can regulate them, then the government can't regulate them. That is exactly how the common use test works, because what we have said through this test is that we're going to let the American people decide how best to defend their lives. We're not going to allow judges or bureaucrats who are clearly politically influenced one way or the other to make that determination. No, we will actually let the American people determine for themselves how best to protect themselves and their loved ones. Okay, then the state of New Jersey got some poor schmuck at the Attorney General's office in a cubicle to spend a whole weekend writing a historical analysis about banning platforms of arms when that analysis has already been done. The whole reason, of course, is that the state of New Jersey wants to convince the Third Circuit that if you throw out the ban on semi-automatic rifles, that means that the fully automatic M16 becomes legal to civilians. Nothing can be further from the truth. But why let the facts get in the way of your argument, especially when you think you're rolling? This leads the state of New Jersey, after going through an analysis of, well, dangerous and unusual probably means dangerous or unusual or unusually dangerous or particularly dangerous or more useful for military service and all these other fantasy-created new rules of law, to state the following. The federal government barely addresses this evidence, other than to acknowledge, as it must, that modern restrictions on machine guns are lawful, while failing to offer a compelling reason why that coheres with its own test. Well, you see, the reason the federal government didn't address any of that history is because it is absolutely irrelevant to this equation, because the historical analysis has already been done. And for whatever reason, and I went and did a word search, and I did not see in any of the petitioner's briefs anywhere the words M16 used, because shockingly, no one is advocating for the legalization of fully automatic weapons. No, this has to deal with lifting a ban on the nation's most popular long gun. All right, oral arguments are set for October 15th. We'll probably get a video out October 16th and give you a quick summary. The case, once again, is Cheeseman v. Platkin. We're going to link up the state of New Jersey's rather pissy little response brief here so you can have a chuckle for yourself. Now, listen, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down in the description box. If you got an idea for a video, click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, that information's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Hey everybody, Bill from Washington Gun Law. Hey, listen, if you belong to a religious organization but you don't have a safety team, what are you doing? And that's why I need to introduce you to Protect His House, the most comprehensive training program available on a nationwide level for church safety security teams. Thousands of churches already trust it nationwide, and here's why you should too. Listen, this isn't some tactical company. They're going to do a top to bottom, front to back analysis of your entire operation, your entire property, to make sure you truly understand the safety concerns. But all of these programs were developed by Tommy Sapp, former SWAT team member and an expert on response to shooting incidents. So listen, there's real life practical experience built in to these training programs. Whether you need in-person training or you want to do it online, they have everything available all the time for every member of your safety team. Okay, and here's a really important part. The instructors at Protect His House, they're not only passionate about the human right of self-preservation, but they are also committed to the acts that occur in places like this. So if you're finally ready to get serious about church security, and if you're finally ready to be trained by people who see the world the same way that you do, click the link below and protect what matters most starting today.